Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss a case wherein the Honorable Supreme Court discussed the poor state of affairs prevalent in the consumer forums across the country due to existing vacancies for the post of president and members that have not been fulfilled since last many years. Let us discuss the pertinent observations and directions by the Supreme Court in this regard. Firstly, it was observed that the legislative intent of empowering the consumers is visible through the enactment of Consumer Protection Act 1986 and thereafter through the Consumer Protection Act 2019. Secondly, the court noted that heavy backlog exists in fulfilling the existing vacancies in the consumer forums and the state consumer commissions across the country. Thirdly, the court directed the states that have not yet notified the new rules under the Consumer Protection Act 2019 for salaries, allowances, and other terms and conditions of service of the President and members of the State Commission to notify such rules within 2 weeks. Fourthly, the court also directed that in case the concerned states fail to notify such rules under the Consumer Protection Act 2019, the model rules of 2020 framed by the Government of India in this regard shall automatically kick off and apply to such states. Fifthly, the court also noted that many states have not yet set up the selection committee in terms of Rule 6, Sub-Rule 1 of the Consumer Protection Qualification for Appointment, Method of Recruitment, Procedure of Appointment, Term of Office, Resignation and Removal of the President and members of the State Commission and District Commission Rules 2020. Thus, such states were directed to constitute the selection committee within a period of 4 weeks. Sixthly, the court further directed that all the vacancies for the post of president or members should be filled within a period of 8 weeks. Seventhly, the electronic infrastructure supporting the consumer commissions and forums was discussed. Such network is titled as Computerization and Computer Networking of Consumer Commissions, CONFONET, and it is being fully funded by the central government. The court directed the states to apprise itself regarding the manner in which CONFONET is being utilized. And lastly, the court also observed that there is a need for a comprehensive legislative impact study regarding the new Consumer Protection Act of 2019 and that such a study should be completed within a period of 4 weeks. Those were the observations by the court. So what are my concluding remarks? As a practicing advocate, I can say that the state of affairs prevalent in the consumer forums across the country is quite abysmal. The Honorable Supreme Court quite rightly noted that there is little endeavor on part of the states to translate the legislative intent of empowering consumers into an administrative infrastructure with requisite facilities. A healthy and robust consumer disputes redressal mechanism is quintessential for smooth functioning of any economy. Total disregard in making appointments to the consumer forums and the commissions has translated into undue delay in disposal of consumer complaints and redressal of consumer grievances. I hope that the directions given by the Supreme Court in this case are implemented in letter and spirit by the states and union territories within the stipulated time frame. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.